We are confident that on the state of the law, that our appeal is recondite. We have raised very strong and substantial issues which will be determined by the Court of Appeal, and we are hopeful that we'll be successful. But the fact remains that in a situation where for any reason, and I've stated this before, for any reason a litigant has genuine apprehension that that litigant may not get justice and had applied for recusal, that the most reasonable thing to do by that judex is to recuse herself or himself from hearing that matter.
It is most unfortunate that the PDP that is supposed to get its house in order in preparations for the 2027 general elections. You could see clearly from the frivolous applications seeking for adjournments here and there from the opposite side. It is very clear from all these applications that you know who are the genuine PDP members who really wants to take this party to where it belongs. How can you, in all purpose and intents, a suit which seeks to address all pending issues, all the issues that have stagnated the party, they are coming up with frivolous applications to the Court of Appeal here and there?
In respect of the one that was filed by us, we took advice and guidance from our team of lawyers that in view of other pending matters, that there may not be need for us to continue with that for now. And on the basis of that, our lawyers filed an application to withdraw without leave under Order 50-2 of the Federal High Court rules. Now, under normal circumstances, what the court should have done was to strike out the matter. But for reasons best known to the judge now decided to dismiss that matter. And we are going to take further advice and guidance from our team of lawyers on what options are available to us, including but not limited to our right to appeal against that ruling. Now, the second case now came up. Now, however, before now, certain orders were made by the judge in respect of the matter, which we felt were orders that had sweeping effect on even the main substance of the matter and being made at interlocutory stages. So our lawyers had appealed, and the appeal has been entered at the Court of Appeal, and we filed an application for stay of proceedings at the Court of Appeal. And all these facts were brought to the attention of the court through an affidavit of facts. And the opponents, our opponents who brought us to court, could not dispute these facts. And so we now had argued that the proper thing for the court to do is to adjourn the hearing of that matter sine die, that is indefinitely, as a result of respect for the Court of Appeal, to enable the Court of Appeal to either take the appeal itself or to take our application for stay of proceedings, either way. Now, the court had agreed with our submission and had now adjourned the matter to the 20th of February for mention. That is probably to report back whether the application or the appeal had been taken and determine one way or another. Now, the most important thing that we are saying is that where an application for recusal is filed before the court, the party is saying that I have genuine apprehension that I may not get justice in that court. And this is one of the few instances where a distinction is drawn between the court and the judge. In all other matters, the judge will stand for the court and the court will stand for the judge. But you are not here saying that the court has no jurisdiction. Yes, the court has jurisdiction, but you have concerns with the particular judex who's presiding over that court hearing it. And in matters of this situation, therefore, is even more foundational. It's deeper than the issue of jurisdiction of the court, because you are now saying that I have fears that I may not get fairness, I may not get justice. And like I've always said, it's not even the matter of a reasonable test. Once that fear is there, the proper thing for the court to do is, okay, send the case back, send the case file back to the chief judge for assignment to another court. Because the moment you begin to say you want to do other things, what ordinary person will say is, what interest does the judge has in that matter? What interest does the judge have in that matter? So for us, like I said, we will now be discussing with our lawyers, and then they will advise us in respect of the first matter. But for the second matter, we shall await the hearing and determination of the appeal and the stay of proceedings before the Court of Appeal. Thank you very much.
Thank you, Chairman. Thank you so much.
Thank you.